we'd like for them to see Squabble as the solution where it's like, hey, I know some basic details about what happened to me and how I'm harmed, and there's a solution for them where I can answer sort of very basic questions in an approachable, non-threatening way, non-intimidating way, non-legalistic way, and get the process done literally in 7 minutes of their lives.
Welcome to Hot Docket, the show where we talk about winning marketing strategies that have built the most successful law firms.
Join us every 2 weeks for the latest trends and tactics to grow your law firm.
Hey everybody, and welcome to the Hot Docket podcast. Today we have on with us Michael Egenthal. We're going to be talking about building a platform for serving thousands of small claim clients. I'm pretty excited for this because I personally have wanted to go do like the small claim stuff, and I'm just so lazy. So this to me is like an answer to some of my problems.
Yeah, I think adding technology there removes a lot of the things that would make that annoying or difficult, and it speeds up the process. And it's also probably an area that a lot of lawyers don't want to get that involved in because it's not as lucrative, or really the juice isn't worth the squeeze for those type of claims. So
yeah, I'm curious to see how this works mechanically, because it feels like there's going to be a lot of bureaucracy and kind of tape cutting to have a technical solution to this, because it's so human, it feels. But that's why we have Michael with us. So Michael, thanks for joining us.
It's an absolute pleasure to be with you guys. Thanks for inviting me.
Of course. To start, I love the name. How'd you land on Squabble? And can you share some other names that you might have been throwing around?
Olive branch, bridge. We were trying to think of names that indicated, obviously there's an adversarial situation going on. It's not terribly pleasant. It's not the most desirable scenario that you want to be in. Nobody seeks this situation out. However, we're not dealing with federal antitrust litigation or a death penalty case. It's a monetary dispute, somewhere around $25,000 and under. And while it's an important and big deal to those that legitimately feel as if they're owed a sum of money, ultimately it's the type of thing that can be settled and we can move on from. So yes, it's adversarial. A squabble is a fight. But it's a little fight. It's a little spat, and one that we wanted to be sort of bubbly and approachable, not to diminish the significance of it, but to indicate that the traditional formalities associated with small claims don't necessarily need to be there anymore, and you can still seek justice.
Yeah, and stepping back from kind of little spats, I bet when you first started your path as an attorney, you might have had a different outlook or what you were going to do. So I'd love for you to just tell us a little bit about why you became an attorney and what that journey looked like for you.
Yeah, I grew up in New York, and my first job out of school was working at the Screenwriters Guild in Manhattan, and I observed sort of outside the conference room doors. I observed the negotiations that were going on between screenwriters, television writers, with studios, and writers trying to get to negotiate favorable conditions for themselves, credits and residuals. And I thought it was an interesting dynamic where you had an artist, a creative type who was working with management to secure, conditions for work that were favorable for them. And the liaisons between those two parties were obviously attorneys who facilitating the negotiations. I was 21, 22, didn't necessarily know where I was going with my life, but that was the initial spark. And then, moved out to San Diego and just never wanted to leave San Diego, and went to law school here. And ran a practice, civil litigation and transactional law for 8 or 9 years, while teaching law as well.
And was that focused on entertainment? Were you doing entertainment law type stuff, or was it broader?
Yeah, it was broader. What ended up happening was I fell into a niche in San Diego whereby, you know, a, a number of my friends were entrepreneurs, and I had begun representing them. So I sort of by default became a startup lawyer, and then I became a lawyer to small businesses and to middle-sized businesses. And next thing you know, you're doing both the transactional work to get entities set up, and then any potential litigation work that comes when a dispute arises. Obviously, in my practice, these were larger scale disputes, but the fundamentals are similar.
How did you move from being an attorney to starting Squabble?
Yeah, so I teach law, as I mentioned, and one day I was in the basement, the depths of University of San Diego Law School, and I was chatting with a student, and we were both kind of dead tired, and we were kind of just like meandering with our minds on a little bit of a break from studying, and we're like, how many people you think threaten to sue someone in small claims and then never actually do it, right? Like, who does that?
I do that.
Right? Yeah, it's like you always hear like, I'm going to take you to small claims, but who actually does it? And it's just like kind of like musing about it, and then started to do a little bit of just superficial research, and then that led to much more in-depth research, and we ended up finding out, hey, there are 3.5 million small claim suits filed in the country per year, but there's on the lower side 40 million disputes in this monetary range each year, and on the high side, 100 million disputes in this monetary range per year. A lot of people who are legitimately owed a sum of money, and are those suits go unadjudicated. People just sort of say, what am I going to do? This process is daunting. I have no idea where to begin or where to end, and they kind of just move on with their lives. And one thing led to another. I'm like, why isn't there a tech solution to this? Why isn't there a modern solution to this? And you put one foot in front of the other, and you suddenly start building out a platform for small claims nationwide, which has not been a small task.
And outside of people just not pursuing claims, which, as you mentioned, is probably the most common way that you can, quote unquote, make a mistake in filing these small claims type cases, are there any other common mistakes that people might make in filing these cases that Squabble is able to walk them through and help them avoid?
Yeah, I mean, the thing with small claims is that it's heavily localized, right? So you're dealing with, you're dealing with usually county-based venues or municipality-based. So the rules are based on kind of either your city or your county, and they're all different all over the country. They share some things in common in that it's a relatively informal, small size dispute, but there are many jurisdictional distinctions. And when it comes to the law, we know it's probably, if you think of the list of the most sort of formalistic, kind of rigid, kind of old school type of professions or industries, you'd probably put law at the top of the list. So we all know that, and that has not changed. And that's a little bit at odds with the the average person's a knowledge base. So there's any number of things in a particular filing, whether it's the type of documents that you're filing, whether it's particular information you're filling out on the documents, whether it's evidence submission that has to go with your documents, certain requests that have to be made with the documents, whether it has to be notarized. There's a number of like jurisdictional idiosyncratic requirements that are desired by a particular clerk that results in a very high rejection rate for small claims filings, which is why it's so frustrating for folks and which is why we've attempted to streamline it.
What do you think that rejection rate is?
Yeah, so it's close to 50%. We've we've been in conversations with a number of folks who have been in the industry in different cities for years, and we've been in conversations with clerks, the clerks of courts in jurisdictions across the country, and they welcome something like Squabble as a solution, because for them it's an incredible inefficiency if they have to reject it and send it back, because that form's coming back again. So it's somewhere around 50 to 60% in a rejection rate, and that's just the rejection rate once folks file. And then there's obviously the dark figure of everyone who just says, I'm not going to file to begin with. So those are the folks that we're sort of trying to reach out to with Squabble.
So what do you think Squabble does better than anyone else currently?
Well, we're the first mover in the marketplace. In other words, we sort of boldly decided, if we're going to do this, we'd like to do it nationwide, and we'd like to code out our product such that one is able to file if they're in suburban Pittsburgh, or if they're in Menlo Park, California, or if they're in Houston, Texas. We'd like for them to see Squabble as the solution, where it's like, hey, I know some basic details about what happened to me and how I'm harmed. And there's a solution for me where I can answer sort of very basic questions in an approachable, non-threatening way, non-intimidating way, non-legalistic way, and get the process done literally in 7 minutes of their lives. So we like to think that the fact that we're nationwide and the fact that we make the process incredibly easy, bubbly, approachable, separates us. And then we also like to think that, the fact that we're providing updates at each stage of the process, makes people feel as if, okay, I know this is a legal matter. There's a lot of anxiety associated with, this is a big deal. I'm filing a lawsuit. So we understand that. So we're providing updates at each stage of the game, right? When folks submit their filing, when their case has been triple checked for administrative issues, when it's been filed, when it's in the clerk's hands, when it's awaiting acceptance, when it's accepted, when service of process begins, when service of process is effective. Excuse me. And so the fact that a user or a plaintiff is continuously updated with transparency and simplicity, we think sets us apart and enables folks to trust us with handling their legal matter, even though obviously they're their own lawyer. We're not anybody's attorney, but they can feel assured that they're being updated at each stage of the process, and it's being overseen with professionalism.
That makes sense. To paint a clearer picture here for some attorneys that might be listening, what are the top 3 most common disputes handled on Squabble? What is what does it typically look like?
Yeah, you mentioned in the intro, this is sort of typically outside of the purview of attorneys. Attorneys, if they get a call for a small claims dispute for a dispute that's not in the monetary range that might make sense for their practice, they're typically referring them to the small claims process, and so some of those types of disputes would be like our bread and butter. The most popular disputes that we see on our platform are small and middle-sized businesses, let's say, who have customers who haven't paid their bills, right? So we have a significant number of dentists and doctors who file squabbles, contractors who haven't been paid, mechanic shops who haven't been paid, HVAC folks who haven't been paid, or an individual who's had a service provider and they're dissatisfied with the job, right? So the construction process wasn't done properly. Their car wasn't fixed properly. So, we're dealing with individuals on one side as plaintiffs who didn't have a service provided properly, and then the service provider attempting to collect payment. So that's one. We have a lot of landlord-tenant disputes in which landlords are seeking to get unpaid rent or back or damages from a tenant who has left the premises in disrepair, or a tenant who's simply trying to get their security deposit back. A lot of personal loans, some tort suits as well. A lot of auto accident, auto negligence cases where it's simply not enough for a personal injury lawyer who might be dealing with more sizable disputes. And one of the ones that we get that you might not think about as much, that's somewhat interesting, is we get a lot of disputes by individuals against large corporate entities. So we've got a lot of suits against, say, an American Airlines, a Chase Bank, a Wells Fargo, and Expedia. These types of corporate entities where traditionally people are like, I'm not going to go against this behemoth of a corporate entity. Where am I actually going to get if I'm trying to recover my $6,500? They actually have a 7-minute solution to be able to get their money back, through a squabble, and we take a lot of pride in that.
How is that typically structured for the ones that are against big companies? Is that like a arbitration, or because we've seen other platforms that are doing mass arbitrations on those, but I'm curious how they're structured for you.
Yeah, so typically in most jurisdictions, it'll be an unenforceable clause in a contract from a large-scale company to require an individual plaintiff to waive their right to sue in small claims. So contrary to popular opinion, individual plaintiffs and customers of large-scale businesses actually do have access to justice. They actually do have an individual right to pursue a claim, and so that's something that we want more people to know about. The ultimate product that Squabble will feature in the marketplace, which is what Squabble was initially introduced as, is a simultaneous filing platform and mediation platform. So our goal is not to flood the courts and increase litigation and create an overly litigious society, but we do want to provide folks who are genuinely harmed, genuinely have a grievance for a particular amount of money, with an avenue and a path to justice. And ultimately, the Squabble product will bring back in the mediation piece where folks are able to resolve the dispute on the platform. The reason why that's not the case right now, why mediation is not on the Squabble platform right now, is because a defendant will not willingly come to the platform to mediate a dispute. So we need the teeth. A plaintiff who's owed a sum of money needs the teeth, right? So they need to be informed through formal service of process that they're actually being sued, which provides them the incentive to come to the platform for mediation.
As a nerd, and not like one of the cool nerds, but one of the like kind of lame nerds, I'm curious mechanically how Squabble works. Can you walk us through the life cycle of a claim, starting from the point when a user first interacts with the application? How are you notified of court filings and movement in the court? How does the application then progress that to the user? What's the feedback cycle look like? Where does human process meet technology in this application?
Yeah. So certainly a well-framed question and an appreciated question. So Squabble is obsessed with transparency and with providing as frequent of updates as humanly possible, because we know there's anxiety associated with the fact that you're entrusting a company to facilitate the filing of your claim and service a process and court preparation. So what happens is if you're owed a sum of money, you come to the app and you enter information, in response to bubbly questions about what happened in your dispute, how much money are you owed, who owes you it, why did they owe you it, where did it happen, etc. That information filters into Squabble's database, and it calculates the appropriate jurisdiction and the appropriate venue in which the claim should be filed. And an individual's claim enters the triple check process, which is a process by which our case review team does 3 different checks of the filing for appropriate jurisdiction, appropriate venue, and appropriate administrative accuracy. Obviously, we can't impact the substance of the claim, but we do make sure that the claim has the appropriate documentation and the appropriate subject matter to ensure an acceptance with the court. So initially, the claim is submitted for review. It goes into a triple check process. There are certain things in the triple check process that we might need back from the user, such as a notarized document or the submission of a piece of evidence like a contract. And if that's the case, the user submits that to us during the triple check process. When triple check is finalized, the user will receive a notification on our platform, on their My Squabble screen, as well as through email, that triple check is complete and the submission is queued for filing. And at that point, within a matter of usually 2 to 4 business days, the claim is filed, and it's either filed physically or through e-file, depending upon the jurisdiction. And the user is notified once it's filed. And once it's filed, it is awaiting acceptance by the clerk, and the user is provided updates on the clerk's processing of the claim and ultimately when the claim is accepted. So when the claim is filed, the user receives an update that the claim is filed, but they'll also receive a copy of their documents to show, to be able to see what actually was filed with the court. Once it's accepted, they'll receive notification that it's been accepted by the court, and they'll receive a conformed or stamped copy of their documents on their My Squabble screen, as well as in an email. And that's when service of process gets initiated, and a formal service of process order is placed with our third-party process server. We partner with a company called ABC Legal, who has been in the service process industry for 20 years and knows the industry nationwide inside and out, and have process servers in all corners of the country. So once service of process is initiated, the user will be updated via email and their My Squabble screen. And when service of process attempts are being made, they'll be updated. And then when service of process is either successful or in 8% of the situations is unsuccessful, the user will be notified and they'll receive accompanying documentation as well. And then the final step is that the proof of service of process must be filed with the court, and users are updated at that point as well, with the proof being attached to the email and available on their My Squabble screen as well. And it's at that point that we await the hearing date. Obviously, jurisdictions vary as to when the hearing date will be. Some jurisdictions, you won't even have a hearing if the defendant doesn't answer the case. Most jurisdictions, a hearing date will be assigned upon acceptance, but others, you have to wait until a little bit later. And users are updated with each communication that's provided from the court. Users are updated by Squabble all the way up until their court date.
All right. I heard in there you said about 8% of the applications get rejected when they're using Squabble. What is the most common reason for that rejection?
The 8% figure was for service of process. So every lawsuit that you file, regardless of if it's a $20 million lawsuit or a $2,000 lawsuit, requires, per the Code of Civil Procedure for that state, that the defendant be formally notified of the lawsuit, which basically just means you need to have a third party hand them a copy of the complaint, the appropriate paperwork, and a summons, which requires them to appear in court. So you have to do this in order to be able to go to your hearing and to be able to collect. So that's a service that is optional with Squabble. So obviously on the Squabble platform, you're not required to select service of process through Squabble, but the vast majority of our users select service of process because they don't want to deal with it themselves. So the figure I was referring to with the 8% is 8% of defendants cannot be formally served upon the first attempt. And so we're actually pretty proud of that figure because industry average for small claims is upwards of, somewhere between 26 and 30%, because you're dealing with folks who may have moved or are evading service or are just simply difficult to find. So in the instances where, if you find yourself in that 8% where your defendant can't be found, we obviously have subsequent service of process orders that can be effectuated. And then we have more in-depth services that are provided by ABC Legal, such as skip tracing and address location services. And if the defendant isn't able to be found, all is not lost, because there are other methods of service that will be valid with the court, such as substitute service, where it's left with a third party, or certified mail, or even service by publication. So there's always a valid way to serve a defendant in almost every case, which is something that is absolutely required in every case, and something that even if folks choose not to select through Squabble, it's something that they want to make sure that they do in a lawfully compliant way.
That makes sense. I'm curious, from the time someone fills out the forms on Squabble, submits all the information, what is the average time it takes from beginning to resolution for folks that are doing small claims? And I'm sure it varies, but just a good rough ballpark.
It definitely varies by jurisdiction. Absolutely. One thing I just want to make clear at the outset, there's no filling out of forms. There's nothing like that. It's a series of bubbly, approachable questions that are very basic. And as noted, you can finish the process. We have obviously access to a significant amount of data about our claims. And so we'll be able to see the duration that it takes, the time it takes for someone to go from start to finish in submitting their claim. And so we have some claims submitted as fast as 4 minutes, and sometimes folks start a claim and then they finish it a month and a half later. But once you've actually submitted a claim with Squabble, your case can be triple checked and filed that day. The longest it'll take to go through triple check and filing is 2 to 4, maybe 5 business days at the most, depending upon whether we need additional information from you during the triple check process. Clerks vary across the country. If you're in New York, they might have a pile of 15,000 claims that are just sitting there, and they're inundated, and they have 7 employees. If you're in a smaller jurisdiction, they might have a pile of 6 claims. They may have a more efficient process at a particular courthouse than another. But ultimately, we usually see an acceptance of a filing within a time period of either 1 day or up to 2.5 weeks. Sometimes it can take up to 4 to 6, even 8 weeks in certain jurisdictions if they're particularly disorganized or they're backlogged, which obviously during COVID was a nightmare. And then the period after that, it took a little bit of time for them to catch up on their backlog. But typically you'll get an acceptance that, the average rate is somewhere around, probably 4 to 6 days. With e-file jurisdictions, you can see acceptance within a day or two. And once you see an acceptance, in many jurisdictions, you're assigned a court date right there. In other jurisdictions, your court date gets assigned later. But typically, the court date is not more than a couple months set from the time that your case has been accepted. And you'll prepare for court, and you'll bring the appropriate evidence, and you will have a judgment within a couple months, which is then enforceable for 5 or 10 years, depending upon your jurisdiction.
So when building out Squabble, what's the hardest legal problem that you've had to overcome?
So I mean, the subject matter of small claims is relatively straightforward from a legal perspective. If you're a plaintiff who's seeking, $7,200 from a defendant, you're not going to have any sort of complex claim because we're dealing typically with breach of contract claims or tort claims, injury claims or damage to property. So the subject matter of the squabbles themselves is relatively basic, which is why it shouldn't be daunting for an individual user to feel like they need to know, they shouldn't feel like they need to know any sort of law, any part of the law in depth. In fact, at a hearing, you actually simply need to explain the facts in depth and present your evidence. No actual in-depth knowledge of the law is required, although, we encourage folks to do research in their area of the law to be able to speak intelligently about it. From a company standpoint, the combination of law and technology, the intersection between the two is a fascinating place, as you guys know, because you're dealing with, by definition, you're dealing with one ethic that is forward-looking and progressive and ever advancing, and the other that is sort of steeped in tradition and formalism and a little bit more conservative and plodding in its pace. And the mashing up of those two together creates interesting dynamics, right? The legal field is not quite ready to deal with the onslaught that they'll see with technology and how it's going to be radically altering the industry. And one particular area that, just to be totally candid, that we are careful with and we're constantly managing and aware of is the area of unauthorized practice of law, right? Squabble was founded and is overseen and monitored and run by attorneys, but we're not lawyers for our users. And it's very important that we make that very clear at various points of the journey for Squabble users. But there's an education gap there, and we have to make sure that our users are very clear that we're not lawyering for you. We have to make sure that in our process, we're not providing any legal advice, exercising any legal judgment, applying facts to the law. And sometimes those lines are blurred, and different jurisdictions, different state bars define unauthorized practice of law in different ways. Some, define it a little bit more narrowly, some more broadly. Whatever the case, those definitions are going to be tested right now, right? What is unauthorized practice of law? I mean, if you type something into ChatGPT and it spits out a legal analysis, is that the practice of law? So the lines are getting blurred, and I think the legal industry is going to sort of need to rethink its rules around unauthorized practice of law. Just sort of, particularly in our case, with sort of balancing the need for individuals to have access to justice while still maintaining a consumer protection type environment, right? We want to protect the consumer from like predatory attorneys or unscrupulous attorneys who are genuinely not licensed to practice or would be providing inappropriate advice. But in the small claims realm, at least we think it's quite valuable for folks to be empowered individually to represent themselves. And sometimes those lines are blurred, and those issues are coming. They're coming fast as legal tech advances, as you guys probably know.
Yeah, something you mentioned and touched on pretty deeply around where legal meets tech, and that intersection kind of resonates with me. And I'm pretty curious if there's been pushback from entrenched players as you've pushed that boundary, whether it's entrenched, meaning there's another company, which I know you're first mover, maybe no other company sprung up yet, or entrenched as in like there's bureaucratic processes that have pushed back against Squabble.
I appreciate that question, because this is a point of passion for me. There is pushback and it comes from sort of the ivory tower, the entrenched forces within the industry. This is, if you're in the hallowed halls, self-declared hallowed halls of a particular law school or academia or in courthouses, you're dealing with a profession that is one that's proud. It's steeped in formalism and tradition, and it has historically valued its place of exclusivity, right? It's defined by its exclusivity, and if when technology advances and allows for more ease of access to justice, that to me is a great thing, but you're going to alarm those who are more traditional in their thinking in the legal field. But I think it's important that we balance, the purity of the law, the scrupulousness of the profession, but also use technology in a way that's able to advance the profession and actually benefit clients, right? We don't, I think there's a lot. I'm pretty passionate about the fact that there's just a lot of inefficiency and bloating in the legal profession, with lawyers billing clients exorbitant rates to pay for their, the breakfast spread in their office and their ocean view offices, and their corporate retreats, and there's a need for for effective legal assistance in a way that is affordable. And if technology can usher in some of that, then I'm all for it. We've actually been welcomed by the clerks, as I mentioned, because of the efficiency it creates on their end. We've been welcomed by attorneys in some capacities because they have a place to refer their claims that might not, be of the monetary value that's appropriate for their firm. But state bar associations, we've come up against a little bit of some headwinds there, right? There's a little bit of looking at a company like ours with a furrowed brow, because it's just not the typical. This is not something that they're used to seeing. It's not something that they've really applied to their typical model of how they address maybe ethics issues or something like that, like an unauthorized practice of law. So I think just like in other industries, we're going to have to be certainly rethinking the way we view how technology is influencing the industry.
So pivoting from that a little bit, I'm curious, looking at the marketing side of your business, how you're currently finding customers.
Yeah, the way we decided to build Squabble was, it was a choice. I'm a lawyer and a teacher, so I was not inherently a business person with business expertise. So I obviously had to bring on a team of advisors and co-executives that could assist. Obviously, I've learned a great deal along the way, but we made a decision early on to prioritize. Hey, if we're going to provide access to justice nationwide, well, let's do this nationwide and let's do it right. So, if you're in Pensacola, Florida, and somebody owes you $6,800, and you answer some bubbly questions and you hit submit, well, we needed a system on the back end that assembles that information in an organized fashion and auto-populates the requisite forms for that jurisdiction and has a seamless way in which that case is filed and monitored and served. And so that process was a labor of love, to be available nationwide in the top 300 most populous jurisdictions in the country. We're representing 78% of the population over the age of 18. You can essentially file anywhere where there's at least a decent sized town or city. So we prioritized creating that database on the back end and having that foundation first, because it would make no sense to be marketing and have a service that was disorganized, untrustworthy, sloppy, and wasn't actually creating the efficiency that we wanted to. So it took us several years to actually build that on the back end. So we prioritized that, and when we finally launched, we simply began with paid search, and paid search has done quite well for us. We think that the way we come at our marketing is sort of from 4 different angles. It's who is the plaintiff, right? Who's our user? Are they a small to mid-sized business, or are they an individual, right? What's their profession, right? Or are they simply an individual? Who are they suing, right? Is it a large corporation? Are they suing a small business, a middle-sized business, their roommate, a smaller landlord, a larger real estate company? So who are they seeking money from? So who is our plaintiff? Who is the defendant in these cases? And what is the subject matter of the dispute, right? What are they suing for in many of the areas that we discussed earlier? What are our common bread and butter types of disputes that we see in small claims? Where are people filing these claims, right? So, jurisdictional differences and venue differences, right? So we're marketing to particular plaintiffs who are seeking redress from a particular defendant regarding a particular subject matter of a dispute in a particular geographic area. So that's how we've organized it in terms of our paid search. And we have finally, in the last couple months, begun a process of creating content for SEO. And it's our task to become sort of the number one trusted voice for small claims nationwide. We want folks to be able to come to us even if they don't want to file and find easily accessible, easily explained, simple information, not just about how to file small claims, but, what do you have to, show in a breach of contract dispute? What do you do when you arrive at court? Is there a virtual hearing in your jurisdiction, or do you have to go in physically, etc.? And that all comes through educational content that we're now prioritizing.
Awesome, Michael. So we are going to wrap up today with a little game. We always have a little game with our guests, and yours is pretty fitting. We called it
Let's
Squabble or Not to Squabble. So
okay,
it fits. In today's game, we're going to give you 5 scenarios. We want you to tell us for each of them, is Squabble a good solution or not? Okay. I'll do the first one. Number 1, landlord refusing to return the deposit on my apartment.
Oh my God. So is this a speed round, or can I talk for like a couple
speed
seconds?
round.
A speed round. Yes.
My girlfriend and I broke up, and she took our dog.
Yeah. Yes.
I won a $500 bet with my
one a lot.
friend, and he's refusing to pay me.
Yes.
I lost a $500 bet with my friend, and he came to my apartment and beat me up with a bat.
Yes.
And the last one here, I painted a client's house for an agreed upon price, $2,000, but they haven't paid me.
Yes. We've seen all of those. Those are very popular squabbles, all of them.
All right, squabble it up. Squabble it up with Michael and Squabble. Yeah. All right. Well, thanks for joining us today, Michael. I learned a ton, and it was great getting to chat.
I really appreciate you guys. Thank you so much for having me.
Of course. All right. Time to recap. I learned a lot about the small claims process, and I'm kind of happy I never filed, because I definitely would have done it wrong and not gotten money and paid money.
Yeah. One thing that seemed interesting, though, is that it seems like the process is actually much quicker than most of the other stuff we typically work with, because those are more complex case types and they end up getting drawn out and all that sort of stuff. So that was something that I was kind of pleasantly surprised by.
Yeah, and I was actually also surprised by the fact that there isn't, like, the pushback is not from the court systems. It seems like the pushback is from like entrenched big law types or what have you. So the court system actually seems to welcome technology like this, which is kind of like flipped on its head the way I thought the dynamic here would work. But in any case, thanks again, Michael, for joining us. And we're going to put all the Squabble info in the show notes, so it's down in the video. And see you on the next one. Thanks for joining. We hope you've enjoyed this episode of Hot Docket. We're your hosts, Bobby and Andrew, founders of MeanPub, the marketing agency for ambitious law firms.
Have questions about marketing or anything we covered today? Email us at bark@meanpug.com.